Good afternoon, ladies and gentlemen. I am going to be speaking about special needs trusts and ethics. I apologize in advance. I have a cold or something, so I probably sound funny. First topic here is special needs trusts and their structures and uses, and kind of a comparison between something called ABLE accounts and special needs trusts. ABLE accounts are an account that was designed to allow persons with disability to control and grow money in a tax-free environment without jeopardizing their eligibility for public benefits like supplemental security income, Medi-Cal, HUD housing, food stamps, a variety of other federal and state benefits. And if you have dealt with anyone who uses these benefits, you know that a lot of them have incredibly strict limitations. I don't think some of them have been revisited in terms of what they cap out the limitations of various resources as for years and years and years. So with an ABLE account, there are various requirements, this is the government after all, and certain limitations. First of all, a person must have been disabled prior to 26 to use the account. A person can only have one account. It can only be funded with cash. The account can only be funded annually up to the annual gift exemption. And the account can grow up to $100,000 and not disqualify the SSI recipient. Or if a person with disability is only qualified to receive Medi-Cal, the account can grow to the state 529 plan limit, which in California is $529,000 fund. The account disbursements must only be for qualified disability expenses. Otherwise, you can trigger a penalty. In most state ABLE programs, on the death of the person with a disability, any remaining funds in the account must be paid back to the state Medicaid or in California Medi-Cal program for any services that were paid since the opening of the account. Now I will get on to, although I think the idea of the ABLE account was very good, and probably it could be coordinated in some ways with the special needs trust. My personal opinion is, generally speaking, although there are exceptions, my people usually get more flexibility with the special needs trust. There are two basic types of special needs trusts: third-party trusts and first-party trusts. And it is important to determine whether the trust you're going to be helping your client set up is third party or first party, excuse me, because the rules of the government benefit programs, most notably SSI and Medicaid, are very different for first party trusts than they are for third party trusts. The type, whether first or third party, affects the drafting of the trust greatly, as well as who is the beneficiary, how the trust is funded, the government's ability to make claims against the trust, a whole bunch of stuff. Excuse me. Generally and basically, a first-party special needs trust is going to be using money that belongs to the disabled beneficiary in whole or in part to fund the trust. A third-party special needs trust uses money entirely from a different person than the disabled beneficiary, a parent, a grandparent, an aunt or uncle. Usually it could be a friend, but usually it is a relative who wants to do this. A third-party special needs trust allows a parent or grandparent to establish a trust for a disabled child or grandchild while still maintaining that disabled beneficiary's eligibility for benefits. And like I've said before, it's called third party because they use the assets of somebody other than the disabled person. And the reason you want to put it into a special needs trust as opposed to just a regular old trust is that if I leave something to my niece who might be disabled and I just leave it as money, it is probably going to ding my niece, because most of the programs for persons with disability have very strict limits on the amount of cash and other types of property a person can own and still maintain their benefits, which sometimes I think kind of causes kind of odd things to happen. For instance, generally, if a person has a house and lives in it, their home is generally considered an exempt asset under a lot of these programs, if not most. However, in California, where we have fairly large property taxes, it can be very difficult to save up enough money to pay the property taxes. There have been bills or attempts at bills to allow people to pay property taxes in payments. Most counties that I know of still do not allow that. And if you live in my county, even people I know who bought their house a long, long time ago, my parents' contemporaries, the ones who are still alive, for a lot of them, their property taxes will be over the $2,000 limit that you can have. So the disabled people have to do some kind of workaround. I've helped several people where they do it with relatives who are holders for the money. Or just I have one where his older brother is just a very kind person and does that for him. So that's why you want to put it in a special needs trust, because it's going to bounce the person out. And because of the way vesting and inheritance laws happen, generally speaking, in California, you want to try and either petition the court as soon as possible or have something set up before the person with the money dies. The reason I say this is if they get the money and then use it for something, it can be extremely difficult to convince the county social worker people who administer these programs, as well as a court, that, well, it's okay several years down the road to put what's left over into a special needs trust. I know a couple of judges who will do that. They're not in my county. But it's generally, if it doesn't happen right away, the person can get bounced out of their programs, which can be very difficult on them. So what people are trying to do, and there's certain wording you want to put in, but the goal of the special needs trust is basically to help the person maintain their benefits, but also to allow them to have money for extra stuff. Most people will do this as a parent or grandparent while their child is alive. Especially the grandparents, they'll try and do something that's helpful, but you want the child not to just a lot of benefits. SSI is very, very small if you're trying to live on SSI, especially here in California. I know that's a caveat to a lot of these things, but also in terms of what you are going to get, what a person who has Medi-Cal and or SSI, what they are going to qualify for in terms of various treatments and other things. There's some medical devices and other things that are nice to have. They can help your life be better, but they are not necessarily considered medically necessary. So they may or may not be covered. Also, all the other nice things that we can have in life, a vacation trip, a trip to Disneyland, a television, well, not television set, but a certain enhancements to their life, like the trip to Disneyland is the one that's uppermost in my mind at the moment, and a variety of other things that aren't necessarily considered exempt property. I have lists of these things in the materials. Make the person's life better. But probably if all you have is SSI, they're not going to be able to pay to live and also go on a trip or get some of these other things. And that's where the special needs trust comes in. Because, here we go. I have these cited in the materials also, first party special needs trusts, there's some sort of, magic words, magic requirements. It's under 42 USC 1396 P, as in Paul, little a, little little a, and 4. The trust has to meet these requirements. It has to be authorized by established by an authorized person or entity, be for a person under the age of 65, be for the sole benefit of the beneficiary, for a person with a disability, be irrevocable, provide for repayment of the state on the death of the beneficiary or the termination of the trust, and it has to require that the trustee gives notice to state agencies of the trust termination, the beneficiary's death, and a change of trustees. Like I said, the third-party special needs trusts are not so limited. Pooled asset trusts. These are still around as far as I can tell, and there's some people who use them. There's some people, most of my clients have chosen not to use them. The idea of a pooled asset trust is that the trust in an organization, generally a nonprofit organization that advocates or wants to help in some way, shape, or form disabled people, will pool, they will create a trust that pools the assets of several people. And once again, you can have first party and third party. Obviously, third party, less requirements, first party, more requirements. But if you pool the assets, the idea is that if I have $150,000 in the life insurance to invest, right now you're going to get decent interest, but a few years ago, not so much. Whereas if there are 10 or 20 or 30 people who are all investing $150,000, you have a much larger sum, and you can often invest in things that will get the group a higher rate of return. Even though each individual is not going to get the whole pot, obviously you share it, but that is the idea of the pooled trust. I have known some people, only a few, many years ago, who used it and liked it. I have known people who thought it was more trouble than it was worth. So, now, who can be the beneficiary? The beneficiary of a special needs trust depends on who's establishing it. Third-party special needs, these have a wider range of possible beneficiaries. And like I've said, the regulations are much less strict. It looks more to the fact of whether or not the person is disabled, rather than some of the different things like the ABLE account, you have to become disabled by a certain point in time. Now, third party, no. First party, a person may in essence be his or her own beneficiary if they're establishing what they call a safe harbor, where you follow the rules of the statute. First party special needs trust, as long as the beneficiary is under 65, they have to have a disability as defined in the SSI rules. And for whatever reason, as far as I know, a first party special needs trust, according to the federal regulations, cannot be set up for a person who is over 65. I am assuming that is because they figure if you're over 65, you're going to get Medicare and you may well get Social Security. So maybe they figure you don't need it. Okay, protecting benefits eligibility. That's the main purpose of the special needs trust. I have language I have a sample trust that has what I think of, as the magic words, I'm sorry, that will protect the person's eligibility for benefits. And the basic requirements, where did my glasses go? Here we go. The basic requirements of a third-party special need trust are very few. The beneficiary, and this is true of all special needs trusts, The beneficiary cannot have any control over the frequency of the distribution, the amount of the distribution. They can't have any power to revoke the special needs trust, or to use the funds or direct the use of the funds in any way. And if these conditions are met, if you have the magic provisions, as I think of it, in the trust, then the trust assets won't be counted for SSI eligibility. And obviously the biggest consideration in most cases when you're establishing this kind of a trust is to ensure the eligibility of the beneficiary for government benefits, while also ensuring that needs beyond those that are covered by the program, that the trust can pay for them. And this is one of the things when your client is choosing a beneficiary, because there are so many different programs and special requirements. You either want someone, probably you may even want more than one person, but you want someone certainly who's familiar with the beneficiary. Obviously the parents and grandparents are, but if they're not going to be around when the trust comes into effect, you maybe a sibling. Some people will actually put together a booklet, diary, a booklet or a binder of instructions about Jimmy likes this, Sarah hates this, things that they like to do, things that they like to eat, what their special needs are, medical needs, things like that, so that the person who is going to take over will understand some basic things. You may also want to have a person, if you know someone who is a social worker, who I have friends who are social workers and they're fairly familiar with this. However, it can be expensive to hire someone like that. Sometimes you would want to have your people go and see if there's a nonprofit that might be able to help. And of course, this depends on the size of the trust. If someone has a lot of money, then it is worth it to allow the trustee to hire the services of someone who understands the benefits, what can disqualify their beneficiary from the benefits, how they go about applying for the benefits if that is necessary. All these different things, because there are a lot of them. And a lot of them are but not all, are in my materials. I won't go into it all now. It would take forever, and many people consider it kind of boring. But you also, one of the things that you would want the person to at least consult somebody about is what things are not covered by the programs and the benefits that the special needs beneficiary gets, because those are precisely the kind of things you don't want to duplicate whatever the government benefits are paying for. That sort of defeats the purpose of the special needs trust, but you want to make sure that the person can get all the extra stuff, that if they didn't have these limits on their benefits, it wouldn't be an issue. And like I said, you definitely want to talk to your person, your client, about who they want as the successor trustee, because some people do kind of an advisory committee that's made up of family members, sometimes the beneficiary's medical personnel, sometimes a social worker, and some people who I have a friend who has he has physical special needs. And as a result of what happened to him and getting this Medi-Cal and such coverage, he has a social worker. And I have told him, talk to your social worker about blah, 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 blah. He has physical special needs. He's a little out there in terms of emotional stuff, but he's not developmentally disabled or anything like that. But I suggested he talk to his social worker about getting him a therapist, because I got tired of being his therapist. I'm not a therapist. I'm not a counselor in law, I'm not a therapist. So you also want to talk about the distribution what kinds of things it can go for. You want to talk about the distribution after the death of the settler, and also after the death of the special needs beneficiary. What is going to happen to it, or if for some reason you also usually want to put in a provision, kind of a just in case provision that allows the trustee or a trust protector, combination of trust protector and trustee, to close down the trust if they decide at some point in time that it would be in the best interest of the special needs beneficiary. So you also want to make sure that you don't have a provision in it. You want to allow the trustee to be able to apply for various kinds of benefits on behalf of the beneficiary. But you also want to make sure that you do not have something in the trust that says that the trustee can't do anything that causes the person to lose any of their benefits. Reason being, if you want to pay to go to Disneyland or some other kind of vacation, depending on the situation, they might not be able to get, it might be too costly to do that. So, depending on how the person did it, if they gave the money, usually going on the vacation itself is not going to bounce them, but they must count all the assets. So if you give them, say, money while they're at Disneyland, because they don't want to be the only one on the bus that can't buy an ice cream or whatever. So you allow the trustee to do that and do not require that they can't do that. In other words, all the cash assets that a person gets during the month technically count against what they're going to get. And so in terms of SSI and such. And so you don't want to hamstring. I've seen provisions that say the trustee can't do anything that's going to affect this in any way. And I think you want to have exceptions to that. You want to put, in this language is in the materials, that the person has a disability, that the distribution is to be for special needs, talking about the distribution methods, that they may pay directly for items or services. And you want to give them leeway to do things that will be good for the client, but without having their benefits cut off. And you can have situations where they're lowered in a particular month, but it doesn't throw them off of the program entirely. Okay. You want to have the trustee's duties and powers, various things. Those are in the material. That the trustee can cooperate with the beneficiary to seek benefits, that they can pay for attorney's fees. You usually want to have the successor trustee has the power to amend or reform the trust as necessary, simply because the law could change. You don't want to be stuck with something that dings the beneficiary because the law changed in a really unanticipated way. You want to note that no court supervision is required. That they can pay for attorney's fees and other expert people to help them maybe invest the money to do the various legal things that they need to do. Okay. And a lot of the other provisions are sort of, I think of them as standard ones that we have in trusts after people die. And you do want to make sure one of the things you have to put, if it's a first party one, is that you have to pay back the state. Not true at this point in time with the third party ones. Okay, I'm just looking to see if there's anything on my list that I have missed. It's generally, these are are kind of sort of revocable trusts. And you want to encourage the trustee while they're administering it. And it is a big job. Some people have more than one. You want to be sure the person is willing and that they're able to do it, that they understand how to make sure that the beneficiary gets the most that they can in terms of benefits from the trust, extra expenses that will make their life nicer without going over into the area of items that have to be counted, countable items. And usually, as a big, broad brush, various types of distribution, usually distributions for items except food and shelter, don't cause ineligibility for the beneficiaries. Usually, items like an automobile, appliances, washer, dryer, microwave, camera, a bus pass usually is not considered. A computer, internet service, phone, a variety of items that you're not going to be able to pay for on the government stuff, but really help. I can't imagine people not having internet, or cell phones nowadays, but it probably happens. And you just want to make sure that the trustee understands how to do this without getting the person dinged. And that's where allowing them perhaps to hire consultants, lawyers and other consultants that will know the rules, or talking to, a lot of the time there are nonprofit organizations that are they have people that are very, very knowledgeable in this area. And because they're nonprofit, they generally do not, I was going to say trust you, they do not charge the people because they're nonprofits. Let me see. Okay. Do we have any questions? I know I talk kind of fast. I am sorry. Where did I put my glasses? Oh, okay. These are like tax stuff. Not my area. Okay. Trying to think, is there something, well, you want to talk to your client a lot. I know I've talked about this before, but it's extremely important. The first one that I did was for a family where we'd been family friends with each other for a million years from my church. And one of the siblings, just because of their training, had become very, very knowledgeable. They had the youngest sibling was a special needs person. And we got a special needs trust. In that case, one was by will and one was by a court petition. But that person was very knowledgeable, and I talked to him about a lot of the nonprofit organizations, many of which he already knew about, that could help him out, and some of the governmental services that could help him out, because there is so much. I find it overwhelming to a certain extent, and I'm an attorney. So I just think that is very, very important. Like I said, some families, the parents will put together a booklet that talks about the programs, their child's likes and dislikes, any agencies. There are also a lot of agencies as well as nonprofits. There are a lot of agencies, I guess they're probably the same, agencies that will help. Put those in the booklet so that the person who's going to be the trustee has something they can fall back on. so that they don't have to start from zero. Thank you. Again, I apologize. I think probably sound very strange. Okay. Come here. There we go. Page 1. One of the most important areas in trust practice, a lot of estate planning practice, but certainly trust, the area of trust, is who is your client, and why does that matter? The reason it matters is because you can have conflicts of interest, and even though they don't always, conflicts to a layperson don't always seem to make sense, they can have big implications for us in our practice. Not only can they get us into trouble, but they can sometimes mess up what we want to do for our clients. So under California Evidence Code, Section 951, a client is defined as an individual who consults a lawyer for legal services or advice. And California case law expands on this, saying one needs to look at the totality of the circumstances and the reasonable expectations of the person in the possible client's position. So what this means is that an informal lawyer-client relationship can occur even if there's no formal contract and no payment. I've known attorneys relatively new, one who's like my age, they're old, so I don't understand it, but no money changed hands, and I'm like, son, let us have he was older than me, so he was more like, Dad, let us have a conversation, because the law doesn't care, regardless of the famous quote by Abraham Lincoln, pay me $1. I think it was $1. I don't think it was a quarter, although it might have been back in the 18 whatevers. A quarter was worth a lot more than it is now, probably. The person asked why, and he said, then you'll know you have a lawyer and I'll know I have a client. And that's the thing. Now, I think it wasn't so much the money, although that often is something that the courts would look to. If somebody pays me, they figure that person has a reasonable expectation that I'm going to be acting as their lawyer. I didn't just take the money because I wanted money. But it goes to the idea that, even as Lincoln said, although he didn't say it in the words of the cases or the statutes, if you're in a situation where you're doing things that are going to make the attorney think he's got a client and the client think they've got a lawyer, that's reasonable expectations. And it is important for practical reasons to define who your client is. But also it can prevent malpractice claims, bar discipline, and in some cases, the unraveling of the client's estate plan down the road. I mean, that sounds a little weird, and I have clients, a lot of clients come to you for trusts. They're married. Many have been married for a long, long time, and they don't feel like it's like, what do you mean conflict of waiver, conflict of interest? And I explain to them what the law says, that the law requires me to tell them about this and requires them to sign an informed consent waiver. But I also explain to them that the reason it's good for them, not just me, although there's a rule that says I got to do it. So, excuse me. So it is good, definitely good for me to follow the rules. I have seen situations, not a lot in my practice, happily. I've seen them more where they weren't my clients whose estate plan unraveled, but somebody else who was a beneficiary came to me. And sometimes I take them and sometimes I don't, because I don't really like ugly stuff. But a disgruntled beneficiary, imagine a situation where it's a second marriage for both parties. Now, they've been married for a long, long time, like 30 or 40 years. They were married young. They had kids from their first marriage. And one of the people brought separate property. into the marriage. Maybe one person didn't or didn't bring very much separate property into the marriage. But down the road, the person who, say, didn't bring a lot of separate property into the marriage, when they're doing their estate planning, they're thinking, well, we've been married for 40 years and Jim always treated my girl like his daughter. So, I figure all our stuff should get divided equally. And Jim may feel like, well, that was property that I got from my parents. And, I think a lot of it is still my property. I never made it community property. And nowadays, people will know that term. Thank you, Google. And even before, people had heard about community property in California. Jim is thinking, that was from my family, from my mom and dad, from my parents. I think my parents would want more of it to go to their biological grandchild. And he is my son and he's my oldest child, blah, blah, woof, woof. So Jim and Sally might get into a little, discussion / tiff about what they want to do. And one of the things as the attorney that you have to warn them about is the fact that they might have this conflict of interest because of community property, separate property, and what people want to do with it. And you are not allowed, I have to tell them, I'm not allowed to advocate for you, Jim, or for you, Sally, no matter what I might think of the merits or the fairness or anything else of the situation. I have to remove myself from it and let you figure that out. And you have to explain to them that one of the things, and there's a waiver in here, I suggest doing different kinds of waivers, but there's a waiver because so often clients come to you as a couple. Sometimes there are family members, the kids who've heard about, Mom and Dad, you need a living trust. My friend's parents didn't have, especially people who were like my age, or actually probably 10 years younger than me. Their parents are up in their 80s or 90s, and my parents couldn't be in their 80s, I don't think, because I'm 72. But their parents are up there, and they've heard that their friends' parents did not have anything, and it was horrible. People fought over it. They went into court. It cost them more. It took a long time, blah, 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 blah. So they bring their clients in because they know you or their friend knows you, whatever. And then you have a conflict of interest, not only between mom and dad, between the husband and wife, potential conflict of interest for what we call joint representation. The law says, basically, if there isn't any waiver or explanation or anything like that, I'm supposed to represent Sally or Jim, single representation. If I want to do a joint representation, Sally and Jim, then I have to explain to them what are the rights that they're giving up. And I have to get what the law calls informed and written consent from each person. And sometimes it extends into other people too. But at this point, we'll just talk about the two people, Jim and Sally, the married couple, come in. Like I said, they have that, even though they don't see it as a conflict of interest. Christine, we've been married for 40 years. What are you talking about? We agree on almost everything, And I explain to them, well, there are situations, and I use the example of people have community property, separate property, kids from her kids, his kids, whatever, that sometimes people want to do different things with it. And I'm not saying that you, Sally and Jim, want to, because it could happen. I have to explain to you. And then I go on to explain that under the law, if some disgruntled beneficiary down the road, maybe Jim's son says, when I was growing up, my dad's parents, my grandparents always told me I was going to get that, or I was going to get more of that, whatever, because I was their biological grandchild. So I don't understand why my dad didn't give me more, why Sally's kid got more. That's just wrong. It wasn't her property. the fact that she took care of Jim for 40 years, et cetera, et cetera, et cetera. The son is just thinking, it was Apple stock that they bought in the 1980s, and I want it. So you have to explain to the clients, if we don't sign this waiver, if I don't explain all this stuff to you, have you initial each right that you're giving up, it is possible that when you pass away, Jim comes into court and says, my dad didn't know that he had a right to just have his own attorney. He didn't know he had a right to have a person advocating just for him. And what the son is really thinking is, and for me, but he phrases it more politely than that. That dad didn't know he had a right to have an attorney just as his attorney. And so if the greedy little son can convince a court of that, he might be able to. There's no guarantee people are going to win with this stuff, but anything's always possible when you litigate. He might be able to unravel Jim and Sally's estate planning. Now, you were their attorney, and you're pretty sure whether or not you did a conflicts waiver that really wasn't what they intended. But the law says you need to do it, and there have been situations where people were just angry. Money can make people behave very badly. Not as badly, my observation in the probate area. That is why I stopped doing family law. In that area, people are already highly upset, and they just get ugly. So you want to do a conflicts waiver for the husband and wife, for Jimmy and Sally. You also want to do a conflicts waiver if you have a friend who brought Jimmy and Sally in. And I will get to the waiver stuff more about the waiver stuff in a minute, but you want to probably also put a little something in a separate waiver that talks about the fact that Jim and Sally's kid, that's my friend, kid friend, understand that she is not a client. I'm not her attorney. I don't have any duty to her. I also tell if the people have something useful to contribute, and they want to stay there. And sometimes they do for a variety of reasons. Although I always make the people leave so I can ask the parents by themselves. You also want to let them know that you're part of the attorney-client confidence and representation. But you want to have at least a smaller waiver that explains that Sally and Jim's daughter you're not my client daughter, you're my friend, you're not my client, and you're waiving any conflict of interest and acknowledging that you are not the client just because you brought them to me. There are also situations where a son or daughter might come with their parents and they want to pay. They've heard this is a good thing, and their parents maybe they have a house, so they definitely are going to go into probate, at least at some point. If they don't do something like a trust with it, they bring their parents to you and they want to pay for them because their parents might not be that rich, whatever. They want to pay for it. You have to do, I always have people do a separate waiver, the child or children who are paying, explaining a number of things to them, that they are not the clients. Any thought that they might have about that, they are waiving, just because they're paying, they are waiving any potential conflict of interest, any potential claim, that they are somehow my client. And furthermore, they understand that simply because they're the money person, and I've had this come up only a few times, and it was situations where, I'd read about this up front, thank goodness. So I'd have the person sign a waiver. Sometimes people believe that, well, I put up the money, you have to do what I say. No, actually not true. So I always have had for many years people sign, whoever was the non-client party that was doing the paying, sign something acknowledging, I'm Sally and Jimmy's son. I am paying their fees. I understand and acknowledge that this does not make me a client of Christine Beraldo, who is their attorney. I understand furthermore that not only does it not make me a client of their attorney, but it gives me no right whatsoever to direct the representation in any way, shape, or form. Some people have this, most people I've dealt with seem to understand that more easily, but a few people have had this idea, even though they signed it in advance, that, but I put up the money, so I should get to have more say. And it's like, would you be your mom and dad? No, that would be no, you would be their child. So I believe it's always good to explain that to the client and explain that, have them sign and acknowledge, and you do it in different paragraphs where you're explaining it. I'm trying to make it short little paragraphs as opposed to one big one, because it seems to be easier for people to get it if it's smaller chunks of information, especially with weird legal stuff. And each one, I understand, and I waive this. With the little, you have the little chunk paragraph, and then underneath a little line for them to initial it, so that they can't say, oh, I just read the whole thing, I had no idea what I was reading. Well, good for you. I tend to, some people that's probably true. I tend not to believe it when people have some financial interest down the road, but I'm a lawyer, I'm very skeptical. So you want to make sure that whenever you have a situation, clearly with husband and wife, and that's the conflicts waiver that I have in the material, because it is the most common, that the Jimmys and Sallys of the world come in and they're sure that, but we've been married for forever, why do we need to do this? We don't have any conflict, blah, 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 blah. You want to make sure that they know what the potential conflicts are, that you have explained it to them. And in the particular waiver, that's in the materials, waiver of conflict and interest. I, Sally, wife, and I, Jim, husband, understand that we have potential conflicts of interest. We're consulting the same attorney for advice about estate planning. We also understand we have certain rights and duties owed to us by attorney that we will be giving up by having only one attorney represent both of us in these matters. And that's one of the other things, is you want to make sure that they also know, because the reason conflict of interest is an issue, basically, is that when you have two people, you don't have just one person, Normally, I would have a duty of loyalty and confidentiality, but a duty of loyalty just to Jim. So if he said, well, I really want, maybe not all this property that I got from my folks, but a chunk of it, a third of it to go to my son, and the rest of the stuff gets divided up equally among my kids. But my parents always led him to believe he was going to get more or all. So, like I said, normally you'd have a duty of loyalty just to Jim if he was your only client. And so you would have to advocate. Maybe Sally gets a different attorney. They can afford to lawyer up, and Sally gets a different attorney, and you advocate with that attorney. No, Jim has always thought, and Sally has always known, that his parents thought their first grandchild, their biological and first grandchild, should get a little bit more. So you would have a duty of loyalty to Jim to advocate for that, whether it made Sally happy or not. And if you're just Jim's attorney, not an issue. If you're doing joint representation, which happens frequently, then you've got to explain to both of them that normally I would just be advocating for you, Jim, and Sally, I'm so sorry, too bad, so sad. But you explain to Jim, but when I'm representing both of you, I can't take sides. I can't say, oh, well, your son should get more. I have to say, nope, you guys, if you want to fight that out among yourselves and then come tell me about it, but I can't advocate for one or the other. And that's a duty of loyalty. And you have a little thing at the bottom, understanding this, we give up and waive our right to this duty of loyalty as to each other with respect to the above described matters. Because obviously, if there's some other situation, they're not waiving it for something else. Just this one between themselves, duty of confidentiality. And this can be very interesting. Generally speaking, you figure somebody who's been married for a really long time, all kinds of stuff they would have, the other person either would have known, they would have discovered it, or they would have told their spouse. But there are things that they might not have told their spouse that could bear on estate planning representation. I had a case where one of the spouses had had a child before they were married. And this can, in a lot of situations, this can affect, oh, I had this other child. So, even though Sally's always thinking of these as our two kids, really it's three. There are rules and different things about how that comes into play, but it is definitely something that can come into play. And I can only think of one that I had over the years. The person came to me because I can't keep that. That was one of the things that I had explained to them, all this different stuff at the beginning, and they signed the little waiver form. And when the person came to me, but I don't want, and I'm like, you've been married for like 40 years. I was just, and the person he could tell I was really shocked and surprised that he'd never told his wife. He was afraid that she wouldn't like him anymore. And I'm thinking, oh, for goodness sakes, it happened before you were married. As far as I can tell, it seemed to have happened before he'd even met her. Yeah, she's probably going to wonder why you waited all this time to tell you, but I'm pretty sure after all this time, none of us is without warts. If she put up with you and all your other warts for 40 plus years, she's probably going to accept this. Grovel a little bit, apologize when you tell her, but I had to tell him, I can't keep this confidential. It's going to be better if it comes from you than from me. He did. And you know what? She didn't leave him. She thought it was, she was a little hurt that he didn't tell her, but she thought it was basically silly that he was so scared after all that time. It was like, hey, nobody's perfect. She was a very nice lady. So, and you explain to them that generally speaking, if you were just representing one, you couldn't tell anybody else about his child before he was married. Even in that situation, I might suggest to the person really that they fess up. But, if they do or not, that's not my decision. And you also need to explain to them the difference between stuff that applies to the representation. I've hidden money. That could be a husband or a wife. I've hidden money away just in case, my mad money. And you have to explain, if something like that happens and you tell me about it, I can't keep it from the other person because it bears on the estate planning. My example of what is not covered by your giving up confidentiality is Sally comes in and tells me, well, when I was really young, this guy did very, very bad things to me and my friend, and I killed him. Okay, I didn't know. That's got nothing to do with the representation with her husband, Jim, and her estate planning. And I explained to her that, that is covered by the attorney-client privilege. Usually I do that. People usually don't tell you stuff like they murdered somebody. I can't think of anybody who ever told me that. On the criminal side, I did have a person or two who told me that, but not in the estate planning side. There are situations in estate planning where killing a person to get their community property, now you cannot do that. They had a law around that. Somebody killed his wife and then said, oh, well, it's community property. I get it. They changed the law on that, thankfully. We don't want people killing each other to get their community property. Not very messy. But you do want them to know there's certain things that don't have to do with the representation that you can keep confidential so they don't feel like I have to just spill everything. Then you have to explain to them, about the possible conflicts of interest. And under the law and the cases as it's interpreted the law, it can't just be, you might have conflicts of interest, love and kisses by. No, you have to discuss with them, like I did, the fact that sometimes there are, the differences of opinion or desire about how we should divide up this separate property that I brought into the marriage. And any number of things where it might not have to do with separate property, community property. One person feels like this person is the oldest, maybe in Johnny and Jane's marriage. The girl is the oldest, and Jane has always felt like she was our first child. She should get more. Girls always have to work harder. Everybody's always dissing us. So, you have to explain that what the potential conflicts of interest are that might come up. And particularly if somebody has mentioned anything during the representation, like at the beginning, usually you don't find out about the money stuff until afterwards, but occasionally people will talk about it. If there's definitely something like that, you want to specifically mention that in addition to the other kind of specific but general things. What I mean by specific but general is it might be this. Somebody might want to do that. And you have to describe a little bit about the might be. You can't just say, I'm waiving the conflicts of interest. According to the courts, a really generic, I'm waiving it, not good enough. This is in the materials. And I always have, like I've said, I always put two little things for the husband and wife. There are two little lines for them to initial under each little chunk of paragraph explaining whatever it is they're giving up so they can initial it. And I always go over it with them, as boring as it often is. And I ask them, do you have any questions about this? Because if it comes up at some future date, I want them to have initialed it, and I want to be able to say, yes, I talked with Sally and Jim about it. I have no idea what their son is talking about. He's a greedy little person, or he's an idiot, whichever. So then at the end, understanding of potential conflicts, blah, 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 that you waive it. We hereby waive any and all of the above rights and conflicts of interest and agree that we wish to have Christine Baraldo represent us and give us advice about estate planning and prepare estate planning documents for us, blah, blah, blah. And they each sign it, husband and wife. I do, like I said, I do a special one if they're kids that bring them in. I also explain to the kids, unless they want to leave, and sometimes there are occasionally issues where the kids know stuff or the parents just feel much more comfortable. One or both parents feels much more comfortable, especially if English isn't their first language. Sometimes somebody's kind of sort of a translator, although I prefer to use actual translators, but that the child understands that they're not the client. They waive any potential conflict of interest they might have, and especially the one about if they're paying, that they're not directing it. Okay, what is next on the list? What did I do with my list? I can't believe that. I'm sorry, give me a minute here. I think because of the cold or allergies or whatever, my brain is a little fried. Here we go. Top legal malpractice risks. Well, like I said, the conflicts of interest, although it seems like something where you haven't done anything in a certain sense, it seems like you haven't done anything that's going to harm your client, like in a PI case where you don't file it within the appropriate statute of limitations, and so their case is gone. I had a recent thing I did not fail to file. I got somebody else's case long after it had been messed up, and it made me so sad because it was a little elderly lady. And by the time she came to me, everything was blown. But, there's nothing basically to waive in that case. I did what I thought was a pretty good job of getting her a bunch of money, even though the people before me, sad. So there are common disputes that happen in this area. Usually, sometimes it's before you're doing the estate planning. Often it's the kind of thing where they come up after you've done the estate planning, where they're similar to the kinds of disputes we find in probate court, where the beneficiaries are disappointed and disgruntled because they didn't get as much as they expected or wanted. In some cases, they got cut out completely, and they want to right this wrong. What they see is a wrong using the courts, and that's why I said with the Sally and Jimmy community separate, et cetera, joint representation, even though it does not prevent somebody from suing if they have this, it can make it a lot harder to win if you have the appropriate conflicts waiver. And if you don't have it, Sally and Jimmy's kids don't have it. The son who wanted to get more, he's, depending on the evidence, he may be able to have an easier time of suing because he's going to say, my dad didn't know, blah, 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 blah. Most of the time, one of the things, and this happens with wills in probate court, but most of the time, one of the things the beneficiary is going to argue is that the trust settler was not was not competent. And that they were just like in a will situation, that they were the subject of undue influence, fraud, or mistake. And sometimes the beneficiary will just approach the trustee at the beginning of the trustees taking over after the person has died, usually, and explain what they think the problem is and ask the trustee to rectify the situation, which can be often puts the trustee under a lot of pressure, especially if it's a situation where the person picked, and people often do for a variety of perfectly good reasons, where they picked a family member, a child, as the successor trustee. And now you don't want to hear your sibling saying, well, mom and dad gave it all equally, and you know darn well they wanted to give me more than you and whoever got. And sometimes, although not always, if the beneficiary doesn't get their way, they often go to court and sue the trustee, alleging whatever basis they think exists for the court to rule in their favor. Oh, excuse me. I do not know why I have this on silent, but it's just going crazy. Spam call. Ooh, fun. Other areas that are really common for people to have disputes in trust disputes. And they're similar, like I said, to probate stuff, because it's basically you're dealing with distribution of a dead person's estate, but not through the court, through the auspices of a trust. They have disagreements with the trustee on how to deal with the trust assets. And this happens a lot. I see it a lot, although the people that I have come to me, I've generally been able to convince them to talk to each other, either formally with a mediator or informally, talk to each other about why it is that they have a problem, what do they think should be different, deal with it. But if a trustee has let something go for a long, long time, usually over a year, and they haven't done very much, sometimes nothing, it can make the beneficiaries feel like, hey, why are you being so slow? And depending on what's happening to the property and the trust, they might have a valid reason. I mean, sometimes the passage of time can make your assets go up or down. Sometimes it's a situation where the trustee, it's gone on for a long while, the trustee didn't do, there's certain notices and things that have to be given when you are a trustee in a trust. And one of them is under probate code section 16,000, I believe it's 16,007.1, but it's right around there. That says within 90 days, you're supposed to give a particular notice to beneficiaries and heirs and people who are mentioned in certain documents. That tells all these people about the fact that the settler died, there's a new trustee, how do you get a hold of the trustee, a variety of things. You also have to, if you're the trustee, give, with a reasonable request, reasonable information, excuse me again, to beneficiaries who ask you about what's happening with the trust, in the trust. Why are you doing this? Why is it taking so long? If people don't respond, they can eventually be taken into court. And that particular one talks about the fact that if you don't do that correctly and in a timely fashion, and the person who didn't get the notice goes into court, if they were damaged in some way by your waiting, they can ask the court and often get compensated for that. I'm thinking a lot of the time, especially lately, a lot of the time things are going up, but suppose somebody died at the right time in, shall we say, 2007, and then the person waited and waited to do anything until the end of 2008, beginning of 2009. That could mean, depending on what the assets were, well, even a house, that could mean a huge, or have meant at that time, a huge difference in terms of how much money you got. So, excuse me. So that's one of the things in terms of top legal malpractice risks. This is more for the attorney advising their person. And I've seen people where I had people on the other side, and for whatever reason, the attorney didn't advise them about the notice. The attorney didn't advise them about the fact that if the beneficiaries ask reasonable information, the people have to tell them. I've seen attorneys do all kinds of stuff that I didn't understand why. But I'm sure I've done stuff that people on the other side thought was ridiculous too. So one of the things that can be quite problematical in terms of top malpractice risks is funding and timing are how I think of the two things. If somebody comes to me and they want to do estate planning, whether it's a trust or will or whatever it is, particularly if it's a trust, I need to make sure that I help the person get the trust, what we call funded, meaning whatever assets they have that are not going to be probate assets, are not going to be passing by way of contract, like an IRA that already has a beneficiary, that those assets, their house, their regular bank accounts, their regular investment accounts, that those get titled into the name of the trustee to Sally and Jimmy's kids as trustees, or I should say to Sally and Jimmy. We're doing it a little headache. To Sally and Jimmy, before Sally and Jimmy died, to Sally and Jimmy as trustees for the Sally and Jimmy Revocable Living Family Trust. If you don't do that, and the item is over, I believe it's $184,500, which most houses are, because for whatever reason, they count this as a gross value. I've had people say, oh, well, not a problem. The bank owns most of my house. And then I have to explain to them about the difference between gross and net. And they're like, oh, and I'm like, yeah. So pretty much if you own real property, certainly in the Bay Area and lots of places in California now, you're going to bump into that. It's not going to be able to go by way of the Small Estates Act. However, the workaround for that is doing a Hegstead petition with the court. And basically, somebody talked about this earlier, but the reason failing to fund and the people having to do a Hegstead petition, if they come to me and do the Hegstead, I feel like, oh, and I've had a couple where it was a friend of mine that had done the trust, and I won't go into the reasons about why it didn't get funded, but it didn't. It didn't get transferred into the trust, and in one case, the people were like, okay, their parent got a discount, and I think that was related to why the house didn't get into the trust. In the other case, not so much, but for whatever reason, the people didn't want to sue the attorneys or the attorney involved, but they could. That is technically, in my book, at least a little bit of malpractice, because it might not mean huge fees or something, but the person is going to have to wait. The person, it's not, I don't think it's going to be extremely difficult to prove to the court in most cases that mom and dad wanted the house to go into the trust. But they're going to have to pay the attorney, they're going to have to pay court fees, blah, 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 blah. So it is going to cost them at least a small to modest chunk of change. And the beneficiaries could feel like, why should we have to pay for this? Mom and dad's attorney blew it. They should pay our costs and fees. And so, like I said, I'm sure some people ask about that. I have done a number of Hegsteads for people. I've never had anybody who wanted me to go after the attorney who accidentally did it. And in one case, I understood why it happened. It was only partly the attorney's fault. So, and the weird thing is, the biggest thing that can push you over into probate is the house. And in my opinion, a deed that mom and dad do is like the easiest. You don't have to get weird stuff, medallion guarantees, prove to brokers and bankers and whatever that these people are really not trying to, violate the Patriot Act or whatever silly thing they come up with. So I just think that's the easiest. It's like, you do a deed, it gets notarized, you take it over to the recorder's office, Bob's your uncle, the trust is funded with the house. And related to this issue of malpractice and whatever risks, related to the issue of funding is also what I think of timing, funding and timing. If people come to you and they are very, very sick, they've got some kind of diagnosis that says they're probably not going to live very long. And I have done stuff where the person had a form of cancer that usually you get symptoms. I mean, it was like the good news and the bad news. They didn't find out about it until a very late stage. They were asymptomatic. Like I said, good news and bad news. The bad news is it means you don't have as long to live, and curing it is like, in their case, basically not going to happen. So the person, and because of that, the doctors didn't realize at the beginning how late in the day their patient was. So they told the patient and his kids, get your affairs in order. And I'd known the family for a million years from church. So I knew and I talked with them over the years about what they wanted. And, the dad wrote some little thing and, gave him the church bulletin and is like, here, ask Chris. She knows what your mom and I want. So, and fortunately, I realized, I said to them that, okay, their mom by that time had developed a form of dementia. But I explained to them, we can do this. There's a statute. All their stuff was community property. There's a statute that lets you go into court, I forget the number now, and say A, B, and C, all this stuff is community property. Dad is compos mentis, mom not so much, but she really wanted to do this, and this is for the good of the community, and mom and dad, blah, blah, blah. And you get an order saying, let dad sign it and put it into whatever you're putting it into. In this case, it was going to be a trust. But I got a call. They thought I started drafting the trust papers and, the court papers, but I got a call very, very like less than 10 days, 2 weeks saying, oh, dad's in the hospital. The doctors didn't realize it was so late in the game. And they said, he's probably not going to live more than a week or two. So fortunately, that particular day, I had time to do what was late in the day. So, I figured we're probably not going to get the trust done. But I had time. The client had canceled, so I started doing a will. I told them, I said, well, I can do a will. You're going to have to get the court's blessing on this, but it's going to do what the people want, which is how they want to give it, and a really basic special needs trust for the youngest special needs child. So I started doing that after the client canceled. And I was so happy because that was like a Wednesday, and by Friday in the morning, late morning, Dad had taken a really serious turn for the worst. And they're like, "What can you do?" So I said, "Happily, I have the will with this stuff done." I realized there was no way with traffic and stuff. They were up, I was down here, they were up in North San Mateo County. There's no way I was going to be able to drive up there because of different traffic crunches and stuff. But even though it was long ago, one of the siblings was an early on, had a cell phone. So I said, get the cell phone, get people who know your parent, who know your dad, who live near there. There was an old friend who lived near the hospital. They were blessed because they were very nice people. And there was a fax at the hospital. So I faxed her the will. She got the witnesses, and I faxed her a couple of pages in bold, all caps, of how you execute a will. And I had her do it on her cell phone, on speakerphone, and did directions for her and asked questions each step of the way to make sure that the different people who needed to be in the room all at the same time were, and it got done okay. So, it wasn't the latest tech. Today we could have maybe done Zoom or something, but it worked. We got the will. It got a really basic special needs trust for the youngest child. That was good. So timing, in that case, I was realizing there could be a timing issue. The dad, your client, you don't know. They don't always know. But if somebody tells you that, and I have had people come to me after the fact where the attorney, a different attorney who started doing their stuff, knew that the person had a limited amount of time and did all this extra stuff that I did not believe. I won't name the attorneys. I think one of them is dead now, so it doesn't matter. Doing all this extra stuff that I did not believe was necessary, and certainly was not necessary if you wanted to get it done because one person in the couple had a condition where it meant they were going to die really sooner rather than later. They could have done something and gotten it done and not had to probate the person's estate. They did have a will, although it was an extremely old will. Most of it was what the surviving spouse would have wanted. So at least that was okay. But having to do a will rather than the trust and not adding in some of the extra tweaks was certainly not ideal. It cost them a lot more. So I just thought that attorney, the person chose not to make a complaint. I do not know why, because this person was a person who always complained about everything. It was sort of funny, but so, and I have done, when the need arose, I have done wills at the last minute in people's houses who were on hospice. I get people to come be the witnesses and different stuff. And it's something that I think it doesn't seem like, in a certain sense, I don't have control over time or even timing if somebody gets sick, but I do have control over telling my people, I'm going to try and do this, over at your house, and I'm going to bring witnesses, and, are you sure you're going to be okay? In other words, compos mentis enough to do it. And if the people are, then I rush over and do it. Because I don't want somebody saying at a later point in time, Mom and Dad had always, Mom was the last one to die. Mom and Dad had always wanted to cut out this kid because they were strange, they used drugs, they whatever. And because you did not hustle and get yourself over the will, it didn't happen. The next topic is client capacity. This is always, or I think this says testator capacity issues, but we're dealing with trust. But it's if it is a will, the person needs to know generally what their how do they phrase it? Basically, what their worldly goods are and who the objects of their affection are. Do they know who are the natural objects of their affection? In other words, are they so far gone that they're like lights on, nobody's home? Some people are so out of it. My younger sister, sadly, who died the end of April of Lewy body dementia, fortunately, because her sister was a lawyer, she had done she and my brother-in-law had done all their stuff long before she got sick. But, had she waited until she was really symptomatic and in the nursing home, pretty sure nobody, including me, well, especially me, would have wanted to do her estate planning, because at a certain point she didn't speak very much. It was very sad. But, a lot of people with dementia or who've had a stroke, some people with a stroke actually recover and will tell you that they knew what was happening. But at the time that they are unable to speak or communicate with you, I would say probably err on the side of they probably don't have capacity. The reason this is important is if a person does not have the appropriate capacity, they're not legally allowed to do a will or a trust or a variety of things, because the law just says you have to have a certain capacity to enter into contracts, to do trusts, to do testamentary documents, a whole bunch of stuff. And one of the things that you want to do if somebody comes to you, especially if the client is the person that is losing or maybe losing capacity, you want to talk with them and see what you think is your estimation of their capacity. And some people, sometimes it's sort of a continuum depending on what their condition is. Sometimes if it's a stroke, it can be today she was good. A couple of days later, she had a stroke and now she's doesn't communicate. So, and all things in between. So in the state of California, if you have a client who you think is starting to get a little funny, unless that person, if they're a longstanding client, unless that person has told you either before that time or sometimes as they're getting there, they know they can't really do a lot of stuff, but they still have a little something going on, that they're okay with you communicating it to family members or to somebody to protect them, to get a conservatorship, to get a power of attorney, whatever it is needed, unless it's good with the client. Under almost all the California law that I have read, California errs on the side of if the client doesn't want it, you have a duty of loyalty and to do what the client wants, not what you necessarily think is going to be good for the client. In fact, there are some cases that say, and some opinions that say the attorney can't even let others know of the attorney's opinion without violating your ethical obligations. I do know, and there are a number of opinions on this. I do know, and I believe it is still the same. I've only found one opinion in the San Francisco Bar Association that allows an attorney who reasonably believes it is in his client's best interest to disclose the client's possible need for conservatorship or other help due to capacity problems. That is the only one that I know of. A lot of them, there's a lot of space where they don't really say anything, but most of the other opinions I've read err on the side of no, you have a duty of loyalty to do not what you think is good for your client, but what your client let you know that they wanted. So one of the things, if your client believes, and I've had a number of people who were actually fine, they didn't, at least at the point that I did their estate planning, though they were older, they did not have capacity issues. They didn't have dementia. They didn't have transit ischemic attacks. They weren't the victims of strokes or any of that stuff. But they believed that they had, and they weren't paranoid. Some families are a little touchier than others, and they believed and knew that there was one or more family members who might question their capacity to do their estate planning. So what I have done is kind of a prevention. An ounce of prevention is worth a pound of cure. Is I have the clients talk with their doctors and have them tested and talked to over a period of time, either a primary care doctor or if they if they're medical insurance, and often nowadays they do, has a gerontologist, a doctor dealing with older people. I have them go to those people and talk to them and have the doctor make notes. And usually I try and do it if it's possible over a period of time, at least a few weeks, sometimes a few months, so that it's not just a one-shot deal where the person is going to, either touchy or twitchy relative is going to argue, well, sure, Aunt Sally was fine that day. Somebody took her there and propped her up and gave her all kinds of medication, but normally she was not. So if you have the doctor do it, make their notes and do letters in their file, and also letters you can put in your file, do it over a period of time. So there's more than just one letter, more than just notes from one appointment with a doctor, one interview with the doctor. And a lot of the time, some doctors, especially gerontologists, are familiar with the conservatorship requirements, the judicial counsel forms that talk about all the different things, capacities and different things. Is a client oriented, person oriented as to time, as to place? Can they do certain kinds of simple cognitive issues, adding and subtracting, and just a variety of different stuff? And it's on, I believe it's the CG judicial counsel forms. If you look up in probate, the conservatorship, guardianship forms, they have one that's for the physician. And it has all these things listed out that the doctor has to do. And it can be very helpful, because if you're pretty sure your client is compos mentis, they are doing well mentally, then you have something in there at or around the time that you did the estate planning showing, hey, great Aunt Susie was fine and dandy, and the doctor saw her on day one, and the doctor saw her down the road, and after that, and she was fine. And there are a lot of people that I've met who are older who are fine. But the fact that you're older than a certain age will lead people who didn't get what they wanted to figure they should argue that Aunt Susie was not fine and dandy. There was something wrong with her. There's also statutes in California. One of them is called the Due Process Incompetence of Determinations Act. It's probate codes, and I have this listed in the material. Probate code sections 810, 813, and a variety of others. Under the Act, there's a rebuttable presumption that people have capacity to act, and that is always pretty much under the case law and other codes, but certainly under the case law, there's a presumption that people have the capacity to act, and a provision that says a person may still act even if they have a mental or physical disorder, and that decisions about capacity should not be made merely on the basis of a diagnosis of a particular condition. In other words, just because I had a client and I had to explain to her, her parent had been diagnosed in the very, 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 very early stages of, I think, Alzheimer's, but it wasn't really affecting him. And I know there are now more ways, to tell early on if someone has dementia. So you might be saying, well, Grandpa probably is going to get dementia. It seems like they might have, this marker or that marker or the other thing. But in her case, it was one of those I had to explain. He wasn't acting weird. He wasn't saying things or doing things that didn't make any sense. And it talks about should not be made merely on the basis of diagnosis of a particular condition. Capacity or lack of it must be determined with reference to the person's specific deficits, how severe they are, how frequent they are, and how and whether there is a correlation between the deficits and the act in question. In other words, if they're going to do, if grandpa, grandma, mom, dad are going to make a will or a trust, does whatever is wrong with them have to have any bearing or correlate in any way on their ability to do that estate planning? Is it severe enough? Is it frequent enough? Is it, I mean, to know there are probably a variety of things that don't really bear on what we're thinking about doing when we're doing our will or our trust. And they talk about one of the things, in addition to capacity, they do talk about mistake. I did have one case where the person who was doing it thought that one of their children had died. That particular child had not died. Of course, it was the most unpleasant, nasty child. So he sued everybody to get, his share and more. And it was just not nice. But in that case, the mistake obviously had a bearing on what the person did, because the way they did a holographic will and the way they wrote it, it was very clear that they thought this person had died. They had not died, obviously. It caused a bunch of problems. So you want to make sure that the person has capacity before you do any of this stuff. Okay. Because obviously, if they don't have the capacity to do it, then their estate planning is going to be vulnerable to all kinds of questions and lawsuits and just a variety of stuff. If you're the person who did it and you didn't notice that they didn't have capacity, or you didn't do anything to show that they had capacity, but down the road maybe they didn't, everybody and their dog may well come after you and say, oh, I should have gotten more. I didn't know. Some of the things dealing with trust beneficiaries, one of the things that you want to remember is that you can represent the trustee. It is more difficult. You can represent a trustee and a beneficiary. I usually get, if I'm going to do that, I usually get, well, not usually, I always get waiver forms from whoever the other beneficiary that's not the trustee is, because that's one of those built-in, potential conflict of interest situations. You can also represent the trustee in their capacity as trustee and in their capacity as beneficiary. There's a court case that says this is okay. It's something that when you're dealing with beneficiaries and also trustees, you want to be careful. If you're just dealing with one or the other, it generally doesn't make such a difference. If you are the attorney, one of the things you do want to let everybody know, if you are the attorney for the trustee, for any kind of personal representative, you want to let the beneficiaries know this, because they will often think this, let them know that you were not their attorney. No, I'm not the attorney for the trust. I'm the attorney for your sister Sue, who is the successor trustee, or I'm the attorney for your sister Sue, who's the executor. Some people have this idea that if you're representing Sue, who's the trustee, or Sue, who's the executor, that, oh, Christine is the attorney for the whole thing, and I have to disabuse them of the notion, no, I'm not your attorney. I'm not giving you legal advice when I help Sue do the legal notices she's required to send to you. I'm just helping her do this. I'm not giving you any kind of legal advice. But a lot of people do think that you're the attorney for everyone. Protecting confidentiality. Okay.
Sorry to interrupt, Christine, but we are out of time. If you could just respond to the question that we had but in California, wills go to probate, and then you can wrap up from there.
Okay. I don't see where it is.
The question is, but in California,
But
wills
in
go to
California, wills
probate.
go to probate. Yes, if there's certain, I mean, and I'm assuming, I don't know what I forget. I did look at the agenda, but I've immediately forgotten it. I blame it on the head thing. If it's not something that has to go, that can go under the Small Estates Act, and that is amount dependent and type dependent. If there is not a trust, in other words, if Susie and Jim pass away and they each have wills, and I do this for all my clients, it's kind of a CYA just in case. I always do a will for everybody that basically dumps everything into the trust. And I say, they're like, but I'm doing a trust. Why do I need a will? I explain that. Well, what if when you've done your trust, you put all your other property, titled it so that all your possible probate property gets into your names as trustees, and then you buy a lottery ticket and you win and you're out celebrating, and this nasty little person runs the red light and kills you. It's like the good news, the bad news, you know. Nobody wants to be dead. Winning the lottery was fun, and your heirs and beneficiaries will be extremely pleased after they get over being sad. But if, and usually it will be, although not always, if it's a big lottery win over the 184,005, then yeah, that could put your probate estate into probate. It could make you have to probate your will. And I'm not sure if this answers the question. If you only have a will, and some people think that having a will means you don't have to do probate. Not true. It just means, you know, if all you have is a will and your stuff is under the Small Estates Act, you know, you still won't have to go into probate. But if all you have is a will and your stuff turns out to be more than the Small Estates Act amount, it doesn't go by way of intestacy. It's still going to have to go into court, but you can choose who and how much and what you want it to go to. It doesn't just go, well, you know, these are what the laws of intestacy are, and it goes the way it goes, and, you know, you didn't do anything, so too bad. But wills don't always, so I don't know if that was your question. Wills don't always go into probate if the person doesn't have any probate estate property that is not either in a trust or in some other vehicle. Well, generally, things that are in joint tenancy, that are in pay on death account, things like that, we don't consider it once it's in that titled in that format. It's not considered usually probate property because it's being disposed of by law or contract in a way that does not require probate. Did that answer your question? Let me know if that answered your question. Okay. Okay. That's pretty much it. I was going to say some stuff about confidentiality. And then one thing I did talk about is, you know, if people do come in to help your clients, often children do for a variety of reasons, let them know, either kick them out or let them know that if they're coming in to help, they are covered by the attorney-client confidentiality. If you talk with your client's financial advisors, you also need to let them know that they can't spread this around, that they are covered by the attorney-client confidentiality provisions. And I think, in terms of doing it fast, that's about